Hi, Richard, are you there? Hi, Richard?
Yes, I'm here.
Hi, there you are.
Yes, at last.
Okay. So somehow you logged on as an attendee, but then you were able to fix it.
Yeah, I logged on and then logged off and logged on again, and this time it worked. So
Yeah.
I don't know.
And now
I don't know
you.
what I did. Yeah. So
I noticed that we have a little bit of lag, so I will be very aware if I ask you a question. There's a little bit of a time lag, so I'll make sure that I don't interrupt you or speak over you.
Okay.
There we go. See, are you noticing that there's a little time lag there?
Yeah, there's just a little bit. I'll be careful about that too. I have to remember.
Okay. Well, as of this afternoon, before we came in, we had over 100 people register for this webinar. Now, we don't always get that many to attend, but that's a very large number. So this is obviously an area of interest out there, and we do already have some attendees who have already signed on. So this proves to be a very interesting and great topic for everyone. And I will tell you, I was a bit concerned because here in the Northeast, we went from 69 degrees. I just read on MSNBC this morning, or just before I came in. Yesterday afternoon at this time, we were 69 degrees, and at the same time, or whenever they measured it, we had dropped to 3 degrees.
Oh, man.
So those types of things can really affect technology and phone and telephone lines and things like that. And then, of course, we had the terrible weather in the Midwest. And in the New England states, I know Buffalo received 18 inches of snow in such a short span of time. But oddly enough, because they are tough and troopers, nothing closed.
Yeah.
Here in Philadelphia, we would have closed the entire city, but in Buffalo, they were able to still manage and go on with their day. So I know that since you're up there in Dallas, Texas, what are your balmy temperatures for today?
It's going to be in the 60s today, but we're pretty we're not prepared for snow and ice. We had a little bit of snow a few weeks ago. It wasn't quite as bad as Atlanta, but they canceled all the schools. And my wife, who lived in Michigan for a while, was looking at this, sort of thin coating of snow and ice on the roads and going, in Michigan, the kids would have had to walk to school. Not only would we not have canceled it, we would have made them walk. So I guess it depends on what you're used to.
Yeah. It's been quite a challenging winter, to say the least, for us. So yeah. And for those attendees who are logged on right now, I just want to let you all know that we will be starting promptly at 2 o'clock for the presentation. It will run an hour, or it may run a little bit over an hour, depending on, the question and answer and discussion time. So I just want to welcome all of the attendees. And we are expecting a great turnout today. So this is a timely topic for all of us. I'm going to silence my telephone for now. We're just going to review a few things here technically. And I know Mr. Hunt has some things to prep for. And then I will be back on to make an announcement again that we'll be starting promptly at 2 o'clock. Richard, do you have anything to say before I silence my mic?
No. I'll be looking forward to starting.
Okay. All right. I will be back in a few minutes. Good afternoon, everyone, and I want to welcome our attendees today to the webinar presentation. And we will be starting very promptly at 2 o'clock. Mr. Hunt is online with us today, so we are prepared to begin on time as scheduled at 2 o'clock, at which point I will outline some of the CLE requirements as well as the bio of Mr. Hunt. So we do look forward to our presentation today. And again, we will start promptly at 2 o'clock. For those of our attendees who need to call in so that they can hear via telephone, the phone number to call in is 1-877-668-4490. Again, the teleconference phone number is 1-877-668-4490. Once you place the call, you will be asked to enter the access code. And so the access code is 622-187-956. That's 622-187-956. And you can also refer back to your webinar invitation, and it will have that information on the invitation itself. And again, we will be starting promptly at 2 o'clock. And so if you have any questions in the meantime, you can enter them into the chat feature, which is located to the right of your screen. Thank you very much, and I will be back shortly. I want to welcome everyone to our presentation today. My name is Carol Kovaleski. I'm Vice President of Operations of the TASA Group, and we will be starting promptly at 2 o'clock with our presentation. If you have some immediate questions, please feel free to enter them into the chat feature, which is located to the right of your screen. And again, we will be starting promptly at 2 o'clock. Thank you. Hi, good afternoon, everyone, and I want to welcome you today to our presentation. We will be starting very shortly with our presentation today with Mr. Richard Hunt, and I want to welcome all of our attendees who have given their time this afternoon. And before we do begin the presentation, I just want to outline, I will go over some of the CLE requirements for those of our attendees who will be applying for CLE credit in certain states, and as well as the code that is required to be entered during the presentation. And I will take my time to review all of these requirements because I know that it is very important that we be able to provide all of that information to you. So this afternoon we want to welcome you to our presentation, which is Understanding, Avoiding, and Defending Accessibility Lawsuits. So here are some of the housekeeping or requirements that we do need to provide as a provider of CLE credits. Before I do that, I want to just explain to you that the webinar today will cover issues surrounding accessibility liability and accessibility litigation, focusing on ADA and FHA requirements. And Mr. Hunt will also discuss some of the trends that we are now seeing in this type of litigation. To give you a little background about our presenter, Richard Hunt, he has more than 33 years trying jury and non-jury cases in Texas. Through his work with ADA and FHA defense matters, he has consulted with an impressive variety of clients. He has worked with developers, retailers, shopping centers, banks, and other enterprises through these litigation means. Mr. Hunt is an experienced guest speaker, as well as a frequent webinar presenter on ADA and FHA lawsuits. Mr. Hunt not only focuses on ADA and FHA lawsuits, but he also represents client disputes that encompass the complete range of business-related litigation. He has worked with state and federal securities law, common law fraud, and the Racketeer Influenced and Corrupt Organizations Act in state as well as federal court. He has also brought these matters before the AAA and FINRA. Mr. Hunt has worked with the prosecution and defense of claims for trademark infringement, theft of trade secrets, copyright violations, breach of oil and gas contracts, real estate acquisitions, and brokerage disputes. He has represented both employees and employers with concern to non-competition agreement disputes, discrimination, as well as theft of trade secrets. But before we begin our presentation today, let me review the CLE credit information. And my name is Carol Kowaleski. I'm Vice President of Operations here at TASA. So if at the end of the presentation you have any questions, you can always send me an email, and we will get back to you as soon as we can with our response. For those of our attendees who do require a code word for tracking purposes, the code word for today is FHA. So during the presentation, we will take short breaks, and during that time, we will ask that you enter this code into the chat feature for CLE reporting purposes. And again, that chat feature is to the right of your screen, and that's where you will enter this code, FHA. Please remember that if you are applying for CLE credit, you must log onto the computer as yourself. In the past, we've had some attorneys who have been sitting with colleagues, but because they did not enter they did not log on their own computer, we were unable to verify that they were in attendance. So please log on to your computer as yourself. If you have attempted to log on and received an error, or if you are listening by telephone, please email the passcode both times that it is requested. And also in that email, please state the time that you entered your code. This can also be used for verification that you are in attendance of this presentation. In addition, please remember to complete the survey that will appear on your screen at the end of the presentation. Some of the states do require that a survey be completed. As a provider of CLE credits, we are required to have supportive information that you have attended, and in many states, again, this survey is required. During the presentation, we will take breaks for Q&A or discussion to take place, and Mr. Hunt does welcome your questions. So again, please use the chat feature to submit your questions throughout the presentation. Then tomorrow morning, we will send out an email with a link to an archived recording of the webinar. And then also before, again, and I cannot stress this enough, that you complete the survey, and that will appear at the end of the presentation. I want to thank you all again for attending our webinar today, and I'm going to turn the presentation over to Richard so we can begin his presentation. So Richard, the presentation is now turned over to you.
Thank you very much, Carol.
Today I'm going to I would talk today about three aspects of accessibility litigation. The first one is simply to understand in a basic way accessibility law. After that, we'll talk about the nature of accessibility lawsuits, and finally we'll conclude with a discussion of how to avoid them and what to do if you get into one. The last section is the shortest one because I'm hoping no one will ever get into a lawsuit. When we talk about accessibility law in the United States, we're really talking about two statutes that dominate. One is the Fair Housing Act, which prevents discrimination against those with handicaps in multifamily housing. The word handicap is old-fashioned, but it's the word that's used in the statute. The more recent Americans with Disabilities Act prohibits discrimination against those with disabilities in public accommodations. So we'll start with what is multifamily housing. To understand the scope of the Act, it's any development that has 4 or more residential units, and then it covers the ground floor units in, say, an apartment complex or condominium complex, plus units that are served by an elevator. It doesn't include temporary lodging, but it does include housing that is sold rather than rented. That's one item of confusion. A condominium development is covered if it has more than 4 residential units, even though the condominiums are for sale. What's a public accommodation? I've given a list here, and which is an abbreviated version of the list that's in the statute itself. But what you really need to know is any place that the public is welcome is covered by the ADA except for planes, trains, and buses, and they have their own statutory systems. So whether you're talking about the lobby to a hotel, a restaurant, a shopping mall, the lobby of a commercial building, in some cases even the lobby of a private practice, like a lawyer's office or a doctor's office, is going to be a public accommodation because the public is welcome there. As you can see, between these two statutes, they cover just about everything, or every kind of facility you can imagine, except for single-family housing. The effective dates of the statutes are important because the kind of liability that the owner or developer of a property has can depend on when it was built. For the Fair Housing Act, the Fair Housing Act design standards apply to buildings that were first occupied on or after March 13th of 1991. And first occupancy has been defined, or is defined, as when a certificate of occupancy is issued, not necessarily when the first occupant moves in. The ADA accessibility guidelines, once again running from the certificate of occupancy, kicked in on July 15, 1992. Those original guidelines were replaced by what are called the 2010 standards. For various reasons, they didn't generally go into effect until March 15th of 2012. And even with that, there are some exceptions. But the accessibility guidelines and the 2010 standards, while not identical, are very similar. And as a practical matter, this later deadline doesn't make a difference in most cases. Now, why do these dates matter? Well, it depends on what, for the ADA and for the FHA, liability depends on when the property was built. If a building was erected and occupied before the effective date of the ADA, the only obligation the owner or operator has is to remove barriers to access if it is readily achievable to do so. So this is not the same thing as complying with the design standards, although it doesn't necessarily make a difference, as I'll explain in a minute. If the building was erected after the effective date of the ADA guidelines, it is required to perfectly comply with all of the design standards that are in effect. So if it was built prior to March 15th, 2012, it has to meet the old standards. If it's built or occupied after March 15th, 2012, it must perfectly comply with the 2010 standards. And I emphasize the word perfectly because one of the things that drives litigation in these cases is that the statute requires perfection. Finally, certain modifications to an existing building will trigger a requirement that areas be made to comply with the ADA standards, the new ADA standards. This is frequently referred to as the remediation or renovation provision. What is misunderstood about this is simply that renovating a building does not necessarily require that the entire building be brought up to the current ADA standards. The renovation requirements are somewhat less than full compliance, although they have to be taken into account. So there's your ADA accessibility. Old buildings, you have barrier removal liability. New buildings, you have to comply perfectly with the standards or guidelines. Now, Fair Housing Act accessibility liability, there's a similar distinction. Although in the case of the Fair Housing Act, it's more important. For buildings that were first occupied before the effective date of the statute, the only obligation that the owner or landlord or manager has is to allow tenants to make reasonable modifications at the tenant's expense. So if you have an apartment complex that was built and occupied prior to the effective date, no matter how badly out of compliance it is with the Fair Housing Act guidelines, your only obligation is to let the tenant make changes at the tenant's expense and only if they're reasonable. On the other hand, if the building was first occupied after the compliance date, every unit in the building that is covered by the Fair Housing Act, which is going to be all the ground floor units plus any units that are served by an elevator, every unit must perfectly comply with the guidelines. So as you can see, there's a huge difference. And as I'll talk about in trending litigation, when a building that was built after the effective date is sold to a new unrelated owner, it suddenly becomes an old building, and the new owner only has liability to allow tenants to make modifications. This is something that the disability advocacy community and the Department of Housing and Urban Development both don't like, and it's a subject, it's going to be an important subject of litigation in the future. But for right now, a new owner essentially becomes liable under the old building standard. The two kinds of liability I've been talking about have to do with the physical structure of the building, the width of doorways, the layout of the kitchens, slopes, and so forth. But both the ADA and the Fair Housing Act have what's called policy or program liability. And this is a requirement, the statutes require essentially that any facility that's covered have programs that are equally accessible to everyone, and that you can't discriminate on in policies or programs. An example might be a store that has a promotion of some kind, as I've seen here in Dallas, for example, where a shopper is allowed to run down the aisles loading a grocery cart full of food, and then they get to keep whatever they load. That's clearly a promotion in which a person in a wheelchair or with a mobility disability has a disadvantage. And so a program like that would be discriminatory unless some way was found to modify the program to put people with these disabilities on an equal footing. So programs and policies that discriminate against those with disabilities can also give rise to liability. The remedies that are available under the Fair Housing Act and the ADA
are actually fairly simple. For private litigation under the ADA, the only remedy is an injunction to correct the ADA violation plus attorney's fees for the plaintiff. And the fact that only injunctive relief is available, there's no damage remedy under the ADA, plays a large part in the strategies for defending these cases. In private litigation under the Fair Housing Act, injunctive relief is available, and that is the most common relief. Attorney fees go to the plaintiff as well, but there's also the possibility of recovering damages. Damages are small in FHA cases because it's very rarely that any monetary injury has occurred as a result of an FHA violation. But the fact that damages are available can keep the cases alive longer than they otherwise would be. Of course, under both statutes, there's the possibility that the government will become involved. Housing and Urban Development has an extensive set of procedures for investigating and bringing administrative law actions with respect to Fair Housing Act claims. And in fact, the Fair Housing Act requires, as a condition to filing a lawsuit, that the complaining party go to file a complaint with Housing and Urban Development first. So you can get involved. Of course, cases that start with Housing and Urban Development are ultimately brought to the courts by the Department of Justice. The Department of Justice itself is responsible for administering the Americans with Disabilities Act. And so it conducts investigations and files suit. And when it does so, it always issues press releases. But I'm not going to spend much time, in fact, I'm not going to spend any time today talking about actions by the federal government because there's just not time to cover those. We'll be talking about private litigation under the ADA and the Fair Housing Act, which is, by the way, by far the most common kind of lawsuit. So, I've talked for a while. Let me pause and see if anyone's got any questions.
I do have just a few questions right now, and I'm hoping that our attendees will submit their questions again through the chat feature. But the first question I have here is, what if my client rents space that is not ADA compliant? Are they liable?
The answer is yes. The ADA applies both to the owner of the property and any person who operates it, which generally means someone who can control the accessibility. So a tenant in a strip shopping center, for example, would have ADA liability for things like the width of the aisles inside the store, the height of the counters, all the width of doors, and perhaps the accessibility of the bathrooms, all things that the tenant can control. The tenant's not responsible for the common areas because the tenant can't control them. It's important for landlords to know, with respect to the interior spaces, the leased spaces, the landlord is still liable. It's impossible for purposes of a third-party private action to delegate liability out to the tenant. Although the landlord and tenant can agree in the lease that one will indemnify the other, from the standpoint of a third party, the owner of the property is always liable for ADA violations, even if they have turned control of the property over to somebody else.
And Richard, does that include living spaces as opposed to commercial space?
Well, it doesn't. First, it doesn't include single-family homes. The issue that arises with apartment complexes has to do with transfers of ownership. And this is what happens is under the Fair Housing Act, the original owner and developer of a multifamily housing project is liable for failures to design and build it in accordance with the guidelines. Subsequent owners don't take on that liability, but some courts have found that the original owner's liability is essentially endless, no matter how long the period out since the building has been built, the original owner is still liable if a way can be found to implement that liability. And there have been cases where the court essentially where someone sued the original owner because the project was not Fair Housing Act compliant, dragged in the current owner so that the court could enter an injunction that ordered the original owner to fix the property and ordered the current owner to give the original owner access to fix the property. So subsequent owners of residential properties don't take on that liability, but they have the possibility of getting hauled into a lawsuit in order to force them to let somebody else fix it up.
Okay, and I have a few additional questions that have just been submitted. But before I go ahead and read those off to you, I'm going to ask all of the attendees to enter the passcode that we mentioned at the start of this program, and again, that is the CLE requirement. So if all of the attendees could enter the passcode into the chat feature, then we'll have a record of their attendance. So the next question, Richard, that I have is, this is from Charles, and he says, you mentioned when the building is erected, excuse me, is significant. What about parking lots? Is it basically when the parking lot was built?
Yes, is going to be the answer to that. If the facility that's a public accommodation is constructed after the effective date, then it's going to that's going to trigger the obligation to comply with the Americans with Disabilities Act. It could trigger an FHA liability as well. I suppose if it were an apartment complex parking lot, but this would generally come up in the ADA where you had a strip shopping center, for example, that was an old strip center, but had a new parking lot created, or they jackhammered out the parking lot and created a new one. But if it's constructed after the effective date, then it's going to need to comply with the relevant law, the ADA or the FHA.
Okay, and then the next question is from Lisa, and Lisa asks, what is the code section or sections for the FHA?
Oh, well, that will take 1 minute more to answer while I look it up. But here we go.
Okay.
Well, was the question the FHA or the ADA?
She has written here the FHA.
Okay.
Well, we can come back to that one.
Sure. It's going to be in Title 42 of U.S. Code, I think starting at Section 3600 or 3601.
Okay. Then the next question from Gary is, to what extent are ADA accessibility regulations relevant to trip and fall litigation claims?
That's a great question. Right now, I think the best authority is that they are not relevant. The very few courts that have looked at this, and there aren't many, have agreed that neither the ADA nor the FHA is a safety statute, and therefore, in most states, a violation of the statute isn't going to be evidence of negligence with respect to personal injuries. I think that as awareness of the statutes grows, I think if there's going to be a growing number of claims made that the statutory violations are evidence of negligence, or maybe even constitute per se negligence, that'll end up being decided on a state-by-state basis, because those are all going to be state law claims.
Okay, and then here's the final question for this break, and this question is from Jeff. How about the van accessible parking on a parking lot in front of an older 50s building?
Another good question. What's going to happen with an older building, a building from the 50s or 60s, doesn't really matter. If it's an ADA building, if it's a public accommodation, remember that the statutory requirement is that the owner remove barriers to access when it is readily achievable. And most courts have said that anything that violates the current standards is a barrier to access. So, for example, failure to have accessible parking spaces constitutes a barrier to access, and therefore it has to be removed if it is readily achievable. And with maybe the exception of some extreme cases, I think almost every court would say that restriping a parking lot or constructing, or re-leveling a parking lot is something that's going to be readily achievable. The only exceptions to that might be cases where there are city requirements for a certain number of parking spaces based on the size of the building, and you can't create the van-accessible spaces without, without going under the number of required spaces. But generally, no matter how old the building is, a failure to have accessible parking is going to be considered a barrier to access, and the courts are going to find that it is readily achievable to fix that parking problem. So I don't think there are going to be very many public accommodations that can escape putting in accessible parking.
Okay, I think that ends our questions for now, and I just want to let everyone know that we will be taking questions at the end of the presentation as well, so please don't hesitate to enter your questions into the chat feature. So, Richard, I think we can move forward with the next slide.
All right. Having covered too briefly the nature of these statutes, I want to talk now about the litigation under them. And the first question, this comes up a lot, is why do we have so much litigation? These laws are more than 20 years old now. It seems like everybody should know what they say, and yet we still have thousands of suits filed every year. And there are a number of reasons for this that have to do with how you can avoid litigation and defend it. The first one is, there's an unreasonable expectation of perfection in the statutes. For buildings built after the effective date, the general assumption is that they must perfectly comply with all of the design standards, which are hundreds of pages long. Of course, a trained architect or contractor is expected to be able to meet those standards, but some of them are so close that the guys who actually build the building are very unlikely to be able to do it. As an example here, I've got a design for an accessible ramp from a parking space to a sidewalk. You can see 10% flares, 8.33% maximum slope. The widths have to be correct. And a number of courts have said, essentially, if you get one of these a little bit wrong, you have violated the ADA. And there's very little tolerance, at least in private litigation, because private litigants will sue over this stuff. The architectural community will point out that you can always plan to do better than the ADA requires, and that if you miss it by a little bit, you'll still be within compliance. But generally, this requirement of perfection generates a lot of litigation. The second thing that generates litigation, or makes litigation easier, is that when a person with a disability sees a violation of the ADA that relates to their disability, that constitutes discrimination under the statute. I've put these pictures of a couple of guys playing basketball in wheelchairs to illustrate the point. If one of these gentlemen saw a ramp that had a slope steeper than 8.33%, regardless of the fact that he's in excellent physical condition and could get up the ramp with no trouble, he could sue for a violation of the Disabilities Act. So when simply confronting a violation is a presumed harm, it makes it easy for people to sue. Another cause of litigation is the myth of grandfathering. And many businesses believe that if their building is older than the effective date of the act, they don't have to do anything. But as I mentioned earlier, the statute requires that barriers to access be removed if it's reasonably achievable. And the courts have generally said that anything that violates the ADA design guidelines is a barrier to access. This doesn't mean that older buildings have to perfectly comply with the ADA guidelines, and it means that they have to at least try to comply. And a lot of businesses don't know that that's an obligation. Another reason is what I call the myth of the joy of ignorance. My clients frequently ask me if they wouldn't be better off not finding out about ADA violations because somehow if they know that they're not in compliance with the ADA, it will be bad for them. This isn't true. The ADA and the FHA are no-fault statutes. You don't have to have bad intent or knowledge to violate the statute, and being ignorant is not a defense. So you're always better off with knowledge. Some other common misunderstandings. The people believe that if you do a renovation that's less than a certain number, $50,000, for example, then you don't have to, that you don't trigger the renovation obligation. That's not true. There are some states, like Texas, where the state law is triggered by a certain expenditure. But under federal law, the amount of money you spend on a renovation doesn't have anything to do with whether it triggers the need to make an area accessible. Another item, most local building codes now include international code standards that also include accessibility items. So people believe, well, my building got passed by the code inspector, therefore I am ADA compliant. That's not true because most building inspectors don't look for ADA compliance, regardless of the fact that it's in the building code. They continue to inspect primarily for safety, and so the fact that the building inspector signed off does not mean that the building is going to be compliant, and it's not a defense, by the way, to a lawsuit. People continue to believe that the Fair Housing Act only requires them to fix up apartments on a one-at-a-time basis. That's true if the apartment complex was built before the effective date. But for new apartment complexes built after 91, every unit that's on the ground floor or served by an elevator must be FHA compliant. And it doesn't matter whether you have never seen a disabled tenant and never expect to see one. Every unit has to be compliant. Finally, there is money involved. The FHA and the ADA permit the recovery of attorney's fees for successful plaintiffs. In California, in addition, successful plaintiffs get a statutory damage amount, which is, depending on the exact procedural things beforehand, $2,000 to $4,000 per violation. That damage, that availability of damages drives litigation in California. Well over two-thirds of the, I think, more than half of the ADA lawsuits in the United States are filed in California because of that damage remedy. But even in the rest of the country, winning attorney's fees is an attractive thing, especially when tort reform has made it harder and harder for the plaintiff's personal injury bar to make money on ordinary negligence cases. So what's happening is the plaintiff's personal injury bar and other lawyers who are interested in new sources of revenue are looking at a statute that gives them attorney's fees and saying, why not? Finally, let's talk a little bit about the litigants. It's very common among businesses, which are my primary group of clients to dislike ADA plaintiffs. It's very common among certain disabilities advocacy groups to absolutely hate ADA and FHA defendants. And so, for example, we see here's a very typical view of plaintiffs and their lawyers under the ADA and FHA. This probably represents the United States Chamber of Commerce view, for example. And then here's the view of non-compliant businesses from the disability advocacy side.
Richard, can I interrupt? Richard,
Sure.
Can I interrupt for a moment? I have a question here, and I think it's timely, so I wanted to interrupt you. Do you mind taking a question at this point?
Absolutely.
Okay. This is a question from, I think her name is pronounced Divya, and she asks, I have a question. FHA design standards after March 13, 1991, ADA accessibility guidelines kicks in July 15, 1992, and she didn't understand the March 2012 date.
Oh, all right. Sure. Only a few years after the original Americans with Disabilities Act guidelines were promulgated as a regulation by the Justice Department, they started a process of fixing them because there were things that both businesses and disabilities groups thought were wrong with the guidelines. The process of fixing them took a long time. And so what happened was the old guidelines were replaced by the new standards, which are called the 2010 standards because that's when they were published. What you have is an overlapping period. If the building was built between the date of the original guidelines and March 15th of 2012, it can comply with the old guidelines. If it's built after March 15th, 2012, it has to comply with the new standards. And there's a little 2-year gap between when the regulations were issued and when they were effective. If you built a building in that time, you could choose which one you wanted to comply with. But what happened is the standards, the 2010 standards, replaced the 1992 guidelines. That only applies to the Americans with Disabilities Act. The Fair Housing Act design standards have never changed.
Okay, and then actually I do have another question here, so if you don't mind, I'll
Sure.
ask that one at this point as well.
Absolutely.
And this is from Charles, and he asks, what is the definition of readily doable changes for an old parking lot before the ADA?
Yeah, the readily achievable standard. It's readily achievable if it can be done without undue expense. That's essentially the definition. Readily achievable is something that can be done without too much expense. And when courts are looking at what constitutes too much expense, they generally look at the revenues of a business rather than its profits. The ADA removal of the barriers to access, in this case, say, making changes to a parking lot, is viewed by the courts as analogous to a maintenance cost. It's a cost that essentially has to be incurred if it doesn't put you into bankruptcy. So, the analogy might be if your air conditioning broke down, for example, you knew you'd have to fix it, at least in the South, in order to keep customers in the store. The court would treat your parking lot lack of accessible parking as exactly the same thing. You need to find the money to do it unless it puts you out of business.
Okay, and then I guess one final question during this question segment. This is from Mark, and he wants to know what, if anything, is being done about the abuse of ADA lawsuits by disabled individuals and their attorneys.
The answer is nothing, at least nothing formal. California amended its state statute, that's the statute that provided for damages, a year ago or so, 2 years ago, in an effort to stop abusive litigation, but the amendments ended up being so watered down that although they added a lot of complexity to the statute, they have had no effect at all on reducing the number of lawsuits filed. Over the last decade, every few years, someone introduces in Congress or attempts to introduce a reform of the ADA with the goal of limiting lawsuits by making it harder to file them. None of those efforts have ever gotten out of committee, and I think it's generally agreed that with the current situation in Congress, it's unlikely that anything's going to happen anytime soon. So there's really no formal effort being made to stop abusive ADA litigation. Some law firms advertise their ability to defend the cases, and they exploit the notion of abuse. I'll talk about that in a minute. And there are some judges, particularly in California and Florida, where a lot of these cases are filed, that are, on an individual basis, taking a more skeptical view of these cases. But in terms of formal effort, there's really nothing happening.
Okay. I think that's going to end this segment of questions. I do have a couple more that are holding in the queue, but we can. I'm going to save those until the end of the presentation when we take our next question break. So, Richard, please continue with your presentation.
All right, thank you. We've seen the devil as a litigant on both sides, but it's important when looking at accessibility lawsuits, and particularly when thinking about how to defend them, to realize that there's not just one kind of plaintiff. The four pictures here illustrate what I think you can call the four kinds of plaintiffs. The guy with the stuffing money in his face is your drive-by or opportunistic litigator. Actually, I take it back. That's the dry cleaning at the top with a bad parking ramp. These are law firms. They usually have a plaintiff or a group of plaintiffs they work with, and they essentially drive around looking for ADA violations. Then they file lawsuits. They almost always want to settle immediately. In California, they want damages plus remediation. In the rest of the country, they want remediation plus attorney's fees. But these lawsuits, although they are numerous, tend to be kind of small-time lawsuits. They're obviously important to the business owner to get sued, but frequently the remediation costs are only a few $1,000s, and the plaintiff's attorney is usually interested in getting out quick with a small amount of fees rather than pushing it to the limit, and so they can be resolved fairly easily. They're annoying. On the other hand, they're almost always based on real violations of the law. The apartment complex in the lower right-hand corner represents a different matter. Apartment complex litigation under the Fair Housing Act is always more complicated because you're typically talking about renovating dozens or hundreds of units. So the expense that's called for in the remediation that's sought is high, and that makes these cases defensible. That also means that the casual drive-by plaintiffs are not interested in these cases because they're looking for a quick settlement. Apartment complex cases tend to be brought by large, legitimate fair housing organizations or by a very small number of plaintiffs' lawyers. Although the defendants don't like the fair housing organizations that bring these suits, they're typically organizations that have been around since the 60s, and these can't be called abusive lawsuits. They're difficult lawsuits and they're expensive, but that are driven by policy considerations rather than just the desire to make money. The upper left-hand corner is a picture of the non-accessible entrance to a Hollister store, and that represents a third kind of litigation, this time under the ADA. There are a number of groups that are disabilities advocacy groups that take on big national chains, Target, Starbucks, Macy's, and so forth, in an effort to create accessibility for a very large number of locations or stores. They're similar to the apartment complex cases in that these are parties that are not looking for a quick settlement, and they're parties that are demanding so much that there's a lot of money at stake, and the cases are worth defending in the sense that they seem to justify the cost of paying the lawyers. Once again, these cases tend to be driven by policy considerations and rather than money, and that requires a different approach. Finally, the guy stuffing money in his mouth represents what I would call the genuinely abusive litigators. And these are a relatively small number of plaintiffs and plaintiffs' lawyers who file lawsuits without regard to the fact that there is or is not an ADA violation. There was a guy in New York recently who was disciplined for doing that. He targeted only small businesses where the owners were unlikely to have enough money to hire a lawyer, and then he would let them off the hook for $500 or $1,000. A lawyer in California was disbarred a couple of years ago for a similar kind of practice. And so these are usually lawyers with a captive plaintiff that really just want money and don't care at all about whether there's an ADA violation. And that distinguishes them from the drive-by litigants, because in the drive-by litigation, there's almost always a real ADA violation. And that is an important consideration when you talk about a defense strategy. I've already covered these next 4 slides, so I'm going to go on to trending now. The trends in ADA litigation today are, on the left you see a guy using American Sign Language. Deaf advocacy groups have not been involved in very much litigation until the last few years, but both the Department of Justice and advocacy groups for the deaf are making a big push to have interpreters or other facilities to aid the deaf available in hospitals and doctors' offices. So there have been a number of new lawsuits. This is something that advocacy groups are looking at, and especially doctors, dentists, other medical professionals can expect to see these lawsuits in pretty significant numbers. The second group, we have a picture of a little puppy. These are the dog lawsuits, the service dog lawsuits. In the last couple of years, the Department of Justice has issued regulations concerning how businesses have to treat service dogs. And simultaneously with that, we've had in the medical community a large increase in the number of diagnoses of mental conditions for which a service dog is helpful, especially post-traumatic stress disorder. So what we have is a lot of doctors prescribing dogs, and therefore a lot of people who want to bring their dog into a restaurant or a store because it's a service dog, and they are aided by the Department of Justice regulations. The reason this leads to litigation, of course, is because under the current statute, there is no way to know if a dog is a service dog other than the owner says so. And there are very few questions that it's legal to ask someone who wants to bring a dog into a restaurant or business. You can ask them, are they disabled, and does this dog help you? And that's about it. Other patrons think that somebody's getting a free ride of some kind, and so it makes them angry. Business owners don't like it because they don't know if it's legitimate or not, and that tends to lead to litigation. There's an equally serious problem on the Fair Housing Act side. The Housing and Urban Development has taken the position that any therapy animal, which is any animal that helps someone out, and it doesn't have to qualify as a service dog. It can be any kind. Under the ADA, it has to be a dog pretty much right now, but under the Fair Housing Act, it can be a parrot, a snake, a toad. Any animal can be a therapy animal. And the consequence is an apartment complex has to accommodate its no pet policy to allow a person with a disability to have a therapy animal. And the accommodations are aggravating to property managers because it involves waiving a pet deposit and waiving a pet fee, and of course giving up a no pet policy. And that leads to litigation. Finally, the W3C, if you're not familiar with it, that's the newly developed or being developed international standard for accessibility of websites. The courts haven't agreed yet, but the Department of Justice has taken the position that an internet site is a public accommodation that must be accessible. In the last few weeks, they entered into a large consent decree with H&R Block concerning accessibility of its website. They've entered into similar agreements with Netflix and a few others. So private litigation hasn't started much, but the Department of Justice has decided that the web needs to be accessible. They are generally, sometime this year they're expected to issue regulations that require accessibility under the standards of the W3C group. And once those regulations come out, the private litigants will start filing suits as well. And so that's going to be I think, a very important source of future litigation, because the same things that lead the drive-by litigants to sue businesses will now be available, depending on how the regulations are written, but will probably be available to litigants who want to sue small businesses who haven't updated their websites to make them accessible. Okay, avoiding litigation, which is what we don't like to do for our clients. It's easy. All you have to do is be perfect. If you don't have any violations of the 250 or so pages of the accessibility standards, those are the construction standards only. That's not including policies, procedures, and other things. Or the FHA design manual, then you won't get sued. But since that's not possible, there are some practical things that every business should do. First, most ADA lawsuits in number are drive-by lawsuits. Okay? It's the lawsuits where the plaintiff is driving around looking for violations. That means if you don't want to get sued, go to the outside of your building and look at the parking spaces, the curb cuts, and the door widths, and see if they need to be fixed. Because it's a fact, many drive-by litigants are never going to get out of their van or car to see if there's more. If your parking is compliant with the ADA, the drive-by litigant won't even stop. So, start with the outside visible part of the building and make it ADA compliant. Second thing you can do to minimize the risk while trying to become compliant is to have a plan. A few courts have said that there is no need to issue an injunction for a business that has already got a plan to become ADA compliant. And if there's no need to issue an injunction, the case evaporates under the ADA because there's no relief the court can grant at all. So what every business should do, if it possibly can, is have an ADA compliance survey done, or in the case of an apartment complex, the Fair Housing Act survey. And let me just digress for a minute here. By the way, the leasing office of an apartment complex is a public accommodation that has to comply with the ADA standards. So apartment owners take note they have two statutes that they have to comply with. But first, get a survey. Second, make a plan based on the survey to make the facility ADA compliant over a reasonable period of time. And depending on how extensive the problems are and the cost, a reasonable period of time can be several years. This is not necessarily a 6-month item. But what the courts look at is there a well-defined plan to make the fixes over a specific period of time? Third thing to do, work from the outside in, which, by the way, is the same thing the Justice Department recommends for businesses that are removing barriers to access. So you start with what's visible from the street, the parking, the sidewalks, slopes and steps, the doors. Going inside a typical business, you look at accessibility to the goods and services, aisle width and the height of checkout counters are both common sources of litigation. The third thing to work on is toilets. Even older buildings can have the possibility of making the toilets ADA compliant without excessive expense. So that's something that needs to be looked at. The last thing is everything else that you find on your survey that may need to be fixed. But the businesses that want to stay out of litigation need to start by defining their problem and then start working on it from the outside in. Businesses also need to look at their policies and procedures. We've talked about the no pets policy, or a restaurant that has a no animals policy. Businesses need to think about whether their policies discriminate against people in wheelchairs, people who are blind, people who are deaf, or people who have some kinds of mental disabilities. And then think about amending them. And it's particularly important on the service dog issue to train employees as to exactly what they can and can't do when they're confronted by a customer who wants to bring a dog into the store, because this is an area where there's a lot of prospect for litigation. I want to emphasize something here. This is not sensitivity training. We're not talking about making sure that everybody on your staff is sensitive to the needs and concerns of those with disabilities, although that's a good thing. What we're talking about is specific instructions. Here's what you can say if someone wants to bring a dog in. Here's what you can say if a tenant says that they have a snake as a therapy animal. Because employees need that kind of specific guidance. They don't need to be told that they need to be sensitive. They need to be told what they can say and what they can't say. Defending lawsuits, we're almost out of time, but fortunately the defense of these cases is very straightforward. First, you don't want to spend a lot of time in court. The reason is because in FHA and ADA litigation, the plaintiffs, if they're successful, always get their attorney's fees paid. And the longer the case goes on, the more attorney's fees will have to be paid to them. Defendants, on the other hand, even if they win, almost never get their attorney's fees back. So a prolonged lawsuit is nothing but an expense from the defense side, and it is a way of making money for the plaintiff's lawyers. The second thing that drives these cases is the physical aspects of accessibility, the curb cuts, the doors, the things that actually drive most of these cases, are objectively determinable. There is not going to be any question as to whether the parking does or does not comply with the relevant standards. The door is going to be 36 inches wide or it's not. The toilet is going to be 6 inches from the wall or it is not. That means that when a lawsuit is filed based on objective ADA violations, if there are violations of the guidelines that can be objectively determined, the defendant cannot win. Because there's no defense to not having a property that complies with the guidelines. except for the possibility that it's not readily achievable because of expense, but the courts have not been favorable to that. At the same time, there's a very strong mootness doctrine. If the claims in a lawsuit become moot because the ADA violations are fixed, then the lawsuit cannot continue and the plaintiff cannot recover attorney's fees. And I'll add a couple of things here. Most courts view the standing of ADA plaintiffs expansively. I don't think I've seen more than a dozen cases out of thousands in which a case was dismissed because the plaintiff had a lack of standing. And this is despite the fact that defendants file motions to dismiss based on standing all the time, and they pursue them at great expense, and they just almost always lose. And defects in pleadings can always be cured by amendment. So defenses based on standing and defective pleadings may have a place, but it's not very frequent. What do you get? You get this one rule: fix first, then fight. If the business has violations of the ADA or the Fair Housing Act, the best defense strategy is to hire a consultant, hire a contractor, and fix it. And then worry about fighting the lawsuit. Because if the problems can be fixed, the lawsuit's going to be either shorter or it may be dismissed entirely based on movement. Fighting first and then fixing after you lose is the most expensive way to deal with one of these lawsuits, because what you'll end up doing is paying a lot more attorney's fees to the plaintiff. Finally, be the good guy. My clients ask me all the time, here in Texas, isn't the judge going to hate the plaintiff? These are federal judges. They're mostly Republican appointees. They're conservative. They like business. Aren't they going to hate these plaintiffs? And my answer is no, they're not going to hate the plaintiffs. And in fact, conservative judges tend to be law and order judges. And if your building is not ADA compliant, you're just a lawbreaker in their eyes. So the key to defending an ADA lawsuit is to not be the bad guy, but to jump on it and be the good guy, so that when you go to court, whatever defects the plaintiff has in terms of being likable or being exploitative are apparent, whereas you can't be painted with the brush of the businessman who doesn't care about people in wheelchairs. Here's some contact information, but it's probably time to allow some questions.
Okay, Richard, thank you very much. And we do have a few questions. One question here from Gary is, what advice do you have for dealing with serial filers of ADA claims?
It's the same advice that I have for individual filers. Most filers of ADA claims are serial filers. The industry of ADA litigation is dominated by people who file multiple cases, one after the other. The important question, though, is not the character of the plaintiff or the character of the plaintiff's lawyer, but whether they can prevail on a claim that there's a violation of the ADA. And so the best approach with a serial filer is to figure out if you've got a problem and fix it as quickly as possible. Now, the good thing about the serial filers is, for the most part, they're not, since they are really driven more by financial than by policy concerns, they'll almost always agree to settle early on if you'll agree to remediate and pay some attorney's fees. They may want a big settlement agreement that says we're going to come back and monitor your remediation efforts, but they almost never do actually come back and monitor. So with the serial filers, it's pretty easy to settle the case. And if there's a real ADA violation, an early settlement is the cheapest settlement you can get. So I've had the best success for my clients in terms of avoiding unnecessary expense when we get a serial filer is to call up the lawyer and say, okay, we're going to fix it. How much do I have to give you to go away? And it may only be a few $1,000s, which is far less than the cost of defending the case.
Okay, and I do have a few more questions. Excuse me. But in the meantime, I'm going to ask all of our attendees to, again, enter the CLE passcode that we announced at the beginning of the presentation. Excuse me. And to please enter that into the chat feature. That's the CLE passcode. And so, Richard, here's the next question for you. So if your parking lot is not ADA, is the owner to receive a correction notice prior to a lawsuit? And that's from Jeffrey.
No, is the answer. Under the federal law, no pre-suit demand is required. And in general, the serial filers will not send a pre-suit demand. Their concern is that if they tell you you've got a problem before they sue you, you will fix it, and they won't be able to sue you anymore, and then they won't make any money. So it's not required by the statute, and most serial filers don't send them. The efforts in Congress to reform the ADA have focused on requiring a pre-suit demand, but as I said earlier, none of them have made any progress. The California state statute now requires a pre-suit demand, but it got watered down to the point that I don't think it has served the purpose of discouraging ADA lawsuits, or UNRU Act is the California lawsuits.
Okay, and then Alan is asking, what percentage of cases actually go to trial and result in judgments against defendants?
I don't know the percentage that actually go to trial, but I'm confident that it is tiny. We see some summary judgments for the defense every once in a while, but if a defendant, once again, if there are objective violations of the ADA, it really doesn't make sense to take the case to trial unless the defendant is determined to teach somebody a lesson or to engage in their own crusade. Macy's and Starbucks have both defended cases against them at great length over many years, but I think even those cases settled before or during summary judgment proceedings, because there's, once again, if the parking space isn't wide enough or the slope is too steep, there's really not much point in going to trial and trying to defend the case if you know you can't win. And on the other side of the equation, once the plaintiffs see that they do not have a legitimate violation, they generally just want to get out as fast as they can because they don't want to waste time. They want to get money from attorney's fees to get out of the case. So it's rare that the cases go to trial.
Okay, we have a couple more questions. Is there any recognized or frequently used formula to calculate how much is undue expenses in defending small businesses or landlords of a small property based on their income or revenue?
I think we're talking about an undue expense for remediating something, for fixing a slope or something of that sort. I don't think there's a formula. I can say that the courts look at revenue rather than profits, but I don't think there's any formula like 20% or 30% of revenues would be excessive. It's going to depend on persuading the court that the expense is so great that it can't be accomplished without essentially putting the company out of business. And even in that case, because the courts have a lot of flexibility in their injunctions, they'll frequently look at a money issue and say, well, it's true, I can't order you to fix everything tomorrow, but I can order you to fix everything over the next 2 years because I think in the next 2 years you'll make enough money, to pay for it over time. So, but I don't think there's a specific formula.
Okay, and then this question, and I have a few more, but we are beginning to run out of time, so I'll move through them as quickly as I can because I know that attorneys have other things on their agenda for the day. This question is from Jennifer. If the defendant has remedied the barrier, is the plaintiff entitled to any other damages aside from attorney's fees, and can the plaintiff receive money simply for being the lead plaintiff in a class action?
For a lawsuit under the Americans with Disabilities Act, there is no remedy other than attorney's fees for the plaintiff. It's pretty common in settling these cases for the plaintiffs to get a little money as a way to make the settlement happen, but there's no legal right to money under the ADA, whether it's an individual or a class action. And in fact, there's some pretty good case authority that if, while the lawsuit is pending, the ADA problems are completely remediated, the court has no choice but to dismiss the lawsuit and cannot award attorney's fees. There's the possibility of winning the lawsuit by remediating and not paying the plaintiff's attorneys anything.
Okay, and then this question is from Charles. If already in litigation and the complaint lists 10 things including low priority things, not parking lot, not access to goods, not toilet, then must everything in the complaint be fixed including low priority things?
To win the lawsuit, everything has to be fixed if it is a real violation of the ADA. You may find that to settle the lawsuit, you don't have to fix everything, or you can stretch it out over some lengthy period of time. That's going to depend a lot on what the plaintiff wants to get out of the lawsuit, and whether they're looking for a quick settlement or not. But to actually win a lawsuit under the ADA, you have to fix everything, whether it's low or high priority.
Okay. And then from Lisa, what is the best way to get the court to invoke the mootness doctrine by motion? By motion?
By motion. My opinion is that the best way to do it is as a motion for summary judgment. It can be brought up as a motion to dismiss, but I think a lot of courts are reluctant to dismiss cases early on, and so I think a motion to dismiss frequently is you do all the research and you file your briefs, and the court says it's going to postpone it until later. So I think a summary judgment stage is the best place to bring up a mootness claim, because at that time the court won't have any qualms, or won't have as many qualms about dismissing the lawsuit.
Okay, and then from Nicholas, what is the impact on the attorney's fees component of the claim if the defending company immediately implements a future plan to become compliant? In other words, does simply creating a plan to be implemented in the future reduce the attorney's fees or otherwise render the claim moot?
There have been a couple of courts that have said a case was moot because there was a plan to remediate, even though the remediation itself had not taken place. I think that's probably a low percentage, chance of success, but a much higher chance of success is to make an offer of settlement, because the plaintiff's attorney's fees have to be reasonable. I mean, by definition, the court can only award a reasonable fee. And if the offer to remediate is a reasonable offer to remediate, then it becomes harder and harder for the plaintiffs to argue that by continuing to spend money, they were being reasonable. Okay,
and then from Peter, you're getting a lot of questions, Richard, I must say.
Okay.
Peter, regarding mootness, are you saying if during litigation the building owner remediates, the litigation becomes moot? Is this the same in California where damages can be recovered?
I'll start with California. No, it is not true in California because the damage remedy remains available even after the remediation is complete. And it may not be true in some other states that have a damage remedy, even though, for example, Texas has a statutory damage amount of $100. That's not enough to make plaintiffs love filing lawsuits, but it might be enough to keep the case from becoming moot. But a pure ADA case, the only relief the court can grant is an injunction. And so if all the violations are remedied, then the case is moot.
Okay, and then from Divya, is it admissible in court to show that a plaintiff filed lawsuits over and over again?
I doubt that it is. Whether that's relevant or not depends on the judge. Some district judges have said when they consider standing that repeat filing was evidence that there was not standing. I think a larger number of judges have said that the fact that cases are filed over and over again is irrelevant to standing or any other issue. So you'd have to look at decisions of your local judge to see if he or she was going to be impressed by that.
Okay. I'm going to close the question and answer segment now because we have really gone over our time. And if anyone does have additional questions, my email address will appear at the end of the presentation, and you can certainly send them over to me, and I will forward those over to Mr. Hunt for an answer, if that's okay with you, Richard.
That's fine, and folks should feel free to contact me directly with the contact information that was up there. I'm happy to chat about it within limits, since I make a living by answering questions. So at some point, I want to send a bill, but I'm happy to chat with anybody who wants to take a few minutes.
Okay, that's great, and I appreciate that. Thank you very much. So just a few closing items for information. This webinar is eligible for CLE credit in California, Illinois, Minnesota, Missouri, New Jersey, Pennsylvania, and Texas. And to ensure that you do receive your CLE credit, as I stated earlier in the presentation, please be sure to complete the survey that will appear at the end of the presentation. In addition, the TASA Group, which is your best source for testifying and consulting experts, I do want to let you know that we do also offer e-discovery and document management solutions. As we did with this presentation, these are free interactive webinars that provide CLE credits for attendees. And then we also do have research reports on expert witnesses. And if you're interested in any of these products, you can certainly feel free to give us a call at the TASA Group. At this time, I do want to thank everyone and take this opportunity, most especially to thank Richard Hunt for his time and effort in creating this presentation for us today. If you would like to speak with Mr. Hunt, or if you would like to speak with a TASA representative regarding an expert witness for your case, please feel free to give us a call at our 800 number. This is a reminder that we will be sending out a link to you tomorrow with the archived recording. And I want to thank you again for attending our presentation today, and have a good day. And this concludes our presentation for today.